So let's start. The defense is going to start laying its groundwork for this. They brought the motion, so they bring their witnesses first. Is that right?
Right.
Okay. So we're hearing between 8 and 10 witnesses could be coming to the stand today, and they sort of laid the groundwork in their opening statements. What really stood out to you?
Probably one of the biggest things that stood out to me was the procedure of it and the defendant's right to a public trial. And I think that in listening to what they were arguing, one thing that Russell Wilson, the lead defense attorney, made a point of saying is, hey, this decision, this restriction of the court or who could get access to it and no overflow, or there was an overflow court, or overflow room the first day, first couple of days, but not after that, that there's nothing in the record that even spoke to why that would be taken away or why this couldn't have been streamed or why this trial would be more restricted. And I think that that's a pretty good argument. I think that they're going to put testimony and information out there to address that, because it's not in the record of exactly that the judge made certain findings in order to restrict that.
Our Sixth Amendment right affords us to a speedy trial, a fair one, an open one.
Right.
So this is gonna come up throughout today's hearing, I feels like.
I think it will. I think that will come up, and I think that also the gentleman's agreement and the context behind that, I think that that'll be really important, and we'll hear a lot of testimony regarding that and each side's understanding of that.
Every defense attorney I've spoken with about these gentlemen's or gentlewomen's agreements that happen, these sort of backdoor agreements, they say they happen but not on high stakes cases like this one. How would you characterize that?
I wouldn't go that far or say that. They happen, and I think it just really depends on to what extent the gentleman's agreement or gentlewoman's agreement would be. I think that sometimes it could just be one small issue matter that we make an agreement on in a high profile, high stakes case, and that's the agreement. Or it could be a group of agreements or a line of things, such as in this case, where there were a lot of things that they agreed on, and it sounded like from the testimony that they were going back and forth as things popped up on, yes, we're good with this, yes, we're good with this, and making sure that they were on the same page.
For the first time we're hearing during a recess, you were there as well. A 1 hour lunch recess turns into a 3 hour recess during that final day. Something clearly happened, and we now know that there's a shouting match that occurred between both sides. How often does that happen?
Well, that doesn't happen that often. The one thing, it sounds like the shouting match was in the judge's chambers, so I would say that although it doesn't happen a lot, that would be the place that would happen versus an open court. You don't want both sides shouting at each other in a public forum. So if it is going to happen, you want it to happen I've seen it happen in a back hallway, in judges' chambers, somewhere outside the presence of the jury, so the jury doesn't hear what's going on.
And Russell Wilson is basically saying the state received the benefit of that agreement without giving up too much, and the defense was in a position where they had to have a non-testifying defendant.
Right.
And so what role do you think all that plays in ultimately this motion for a new trial?
Well, I think, and what I kind of understand is I think that there will be witnesses, maybe defense counsel, that might testify in this to say, this is what my understanding of the agreement was. This is how it affected Mr. Anthony's decision to testify or not. I think that there's still so much that we don't know yet, that we haven't heard what the witnesses would say regarding that agreement. But I think it is really important, because the defense would, if the defense and what they're saying right now is that agreement and the state's not following that agreement when it came to the defendant testifying took the defendant's right out of his hands to testify, because he could have been impeached by extraneous offenses that the state had. And the agreement was that neither side would use the extraneous offenses and that they would try the case from inside the tent, is what they say.
We had one witness up today, Derek Jackson, who was a former PIO for the county. Why do you think he was brought up by the defense?
Well, I think he was brought up by the defense, one, because he, whether you could say leaked or gave out scheduling information that supposedly was under the court or the gag order, and he ultimately was fired for that. But he was called, I think, by the defense, one, to just say, hey, this guy got fired over just giving out information that typically would be public, right? You could get online, you could see when certain hearings were. And so I think that that's important. I think one thing as well that I heard the state talk about is, hey, weren't there safety concerns? Because the state's going to say, well, we had to shrink this trial. We had to make sure that this trial was very monitored because of safety concerns. And as Worski has said in the hearing, people coming from outside of the state and causing and stirring things up. And so I think Mr. Jackson's testifying, yes, I was privy to that. I was privy to the hate messages that the county was getting, specifically that Judge Tucker was getting after she lowered the defendant's bond. And so I think that that's the thing that both sides are calling him as a witness. I think Bill's calling him or questioning him to confirm that there were safety concerns, because that's the state's argument.
And the defense's argument is, at the same time, was there anybody who was arrested? Was there anybody who was convicted of those things? Why bring that up?
Yeah, so Russell, who's a brilliant attorney, was questioning the witness to see about his knowledge of, okay, y'all have identified that there were threats and concerns for people's safety. Who was arrested? And he said, no one. And so I think it kind of takes, Russell's trying to draw some of the sting out of this whole argument that everyone was in danger and there was fear and there were these safety concerns, because at the end of the day, no one was prosecuted for it.
Anything else you want to add?
No, I think it'll be interesting to just hear what else comes to light later on today. I think, Russell has some very strong points from his motion, and Bill Worski, you can tell he's animated. He's really addressing some of those concerns from the state side to say there's some safety concerns, and now we'll see, as we hear what the gentleman's agreement was, everyone's response to their interpretation of that. So I think that there should be a lot more information that we'll get this afternoon, and I look forward to that.
Last question. Have you seen Bill Worski amped up like he is right now? I think he mentioned it multiple times. Why are we talking about Waller when we knew about these threats?
Right.
And so why do you think he's as amped up as he is?
Well, I think he's amped up because I think at the end of the day, as a prosecutor, being a former prosecutor, I think that to some extent you feel challenged on that you wouldn't do something the right way. And I think that probably some of that emotion, and if you know Bill, he's very emotional, and he can, if he's adamant about something, you're going to know he's adamant about something. And so I think that that's what we're seeing. It's not an uncontrolled emotion. He definitely knows what he's doing. He's making good points. But I just think that that's kind of what it goes to. And I think that he's saying, we knew about Waller. You're arguing that we didn't lay groundwork to these things because we didn't know what was going on. But we dealt with this whole situation with Waller in purview, as he talks about appellate being with them, walking the whole time alongside them to make sure that they were doing things the right way. So I think that that's why you're seeing Bill a little bit more amped up, is just, I think he feels strong about what he's arguing, and that's just who he is.